Okay, we're live. 25 days before the exam, rather than freaking out, the best way to study quickly what you need to cover is by using BARBRI's essay writing outlines. This is something that I'm going to do as long as I can, and intending to cover a few different bodies of law, starting with agency and partnerships. For agency, the outline approach or the essay writing approach appears to be an outline. Agency is broken into 4 parts: formation, duties owed by agent, duties owed by principal, and remedies. Within formation, 1, 2, and 3, you'll discuss capacity, consent, method of formation, be it by action or by operation of law. Subpart B, duties owed by agent. 3 of those are loyalty, obedience, and care. Duties owed by principal include compensation, reimbursement, cooperation, and duties under the contract. Remedies to the agent and remedies to the principal. In the second part, contract liability is broken into 2 subparts. Does the agent have authority, and contract liability to third parties? Whether the agent has authority involves a discussion of authority, actual, express, actual, implied, and apparent authority, ratification, and termination. Where's my YouTube at? Just making sure that this is seen. Anyone who doesn't like it, since I just realized I have 126 viewers, anyone who doesn't like it should just log off. We're going to go like all night. Contract liability to third parties, read that. Tort liability under theory of respondeat superior. Part A, employer-employee relationship. Part B, conduct within scope of employment. So for an agency authority template, the way that she'll begin writing is, if the question asks whether the principal is liable for the contract, use the sample template below. Please be flexible when applying the template. To determine if the principal is bound by the contract, whether the agent has the authority to enter into the contract must first be determined. Actual express authority. Express authority is that authority contained within the 4 corners of the agency agreement and those expressly granted by the principal. Here, ... do your analysis, which is shocking that you can just begin your analysis that quickly. First, again, I'm just going to read that again because the first section doesn't even have a title. To determine if the principal is bound by the contract with a third party, whether to determine this, first address whether the agent had authority to enter into the contract for the benefit of the principal. And then you'll go to the 3 areas that I stated before, starting with actual express authority, actual implied authority. Implied authority is authority that the agent reasonably believes she has as a result of the principal's actions. Here, ... termination of actual authority. Termination of actual authority raises only if it's an issue. It occurs by either party's unilateral termination. Here, ... conduct your analysis. Apparent authority is the next big section. Lingering authority, ratification come next. So apparent authority arises from reasonable belief of third parties. It exists if the principal holds the agent out as possessing certain authority, thereby inducing reasonable reliance by others on that authority. The third party must reasonably rely on the holding out. Here, ... conduct your analysis. Lingering authority, raised only if an issue. Where an agent's actual authority has terminated, he will have apparent authority to act on the principal's behalf as to all third parties with whom the principal knows he dealt, unless and until the third parties receive either actual or constructive notice of the termination. Here, ... raise if an issue where an agent's actual authority has been terminated, but third parties rely on a written authorization of agency, the agent's apparent authority is not considered terminated. The principal must take back all written certificates of agency and authority in order to terminate authority. Here, ... Ratification. A relationship is created by ratification when an agent purports to act on behalf of the principal without any authority at all, but the principal subsequently validates the act and becomes bound. For ratification to occur, the principal must know or have reason to know all material facts except the transaction and have capacity. ... Here. So, in conclusion, ... insert conclusion and be responsive to the question. So, without dwelling on that, we're going to move right into the essay writing approach for partnerships. So I thought, so I actually am going to dwell on that just a little bit. I might even read it again. Actual express authority is that authority contained within the four corners of the agency agreement and those expressly granted by the principal. Implied authority is authority that the agent reasonably believes she has as a result of the principal's actions. Termination of actual authority occurs by either party's unilateral termination. Parent authority arises from reasonable belief of third parties that exists if the principal holds the agent out as possessing certain authority, thereby inducing reasonable reliance by others on that authority. The third party must reasonably rely on the holding out. When an agent's actual authority has terminated, he will have apparent authority to act on the principal's behalf as to all third parties with whom the principal knows he dealt, unless and until the third parties receive either actual or constructive notice of the termination. Where an agent's actual authority has been terminated, but the third parties rely on the written authorization of an agency, the agent's apparent authority is not considered terminated. The principal must take back all written certificates of agency and authority in order to terminate authority. Ratification is a relationship created when an agent purports to act on behalf of the principal without any authority at all, but the principal subsequently validates the act and becomes bound. For ratification to occur, the principal must know or have reason to know all material facts except the transaction and have capacity. So now we're going to move on to the essay writing approach for partnerships. This is just outlined again into governing law, speaking to RUPA, probably like the Revised Uniform Partnership Act, as opposed to UPA, and contract rules apply. Requirements for formation are intent, agreement, capacity, legal purpose, consent of all partners. So actually, I'm going to speak a little slower. Intent, agreement, capacity, legal purpose, and consent of all partners. And last under formation is actually second to last is factors to imply a partnership is 1 and 2, the intent of the parties, and 2, the sharing of profits. There's an exception, which is payments for a debt, services rendered, rent, annuity of retirement benefits, interest on a loan, or sale of goodwill of a business. Aren't sharing of profits and aren't relevant factors to imply a partnership. Partnership by estoppel is the last part under formation. Part 2, partnership property. A, partner's intent. B, factors to determine whether property belongs to the partnership. For real and personal titled property, apply RUPA. Belongs to partnership if titled in Romanet 1, partnership's name, or Romanet 2, names the partners with title holders, capacity as partner, or existence of a partnership. B, presumed partnership property if purchased with partnership funds. And C, presumed separate property of partner if held in the name of the partner. Title does not indicate capacity of partner or partnership, and partnership funds were not used. And second, in relevant factors to determine if property belongs to a partnership is when the property is not titled, apply common law. Those factors include whether partnership funds were used to acquire the property, the use of property by the partnership, listed in partnership books as an asset, close relationship between property and the business, improvement with partnership funds, and maintenance with partnership funds. And lastly, under partnership property, Part C, partners' rights in partnership property. Roman numeral 3, or the third subpart of your essay, will include rights and duties of partners. It potentially could include rights and duties of partners. Part A, rights, management. All partners have equal right to participate in the management and control of the partnership unless there is a partnership agreement that provides otherwise. Distributions. This is for their rights, but they're not breaking each of them down. 2, distribution. 3, remuneration. 4, indemnification. 5, contribution. 6, inspection. And 7, lawsuits. So remuneration, in other words, payment of a salary, is actually not a right. It's just listed here, but it's not a right unless it's stated in the partnership contract. So subpart B under the rights and duties is now the duties. And there's 4 that are discussed. Starting with the duty of loyalty, A, B, and C. A, account for all profits or other benefits derived by the partner in connection with partnership business. B, not deal with partnership as one with an adverse interest. C, not compete with the partnership. Duty of care, A and B, must refrain from engaging in negligent, reckless, or unlawful conduct. B, must refrain from engaging in intentional misconduct. 3, duty of obedience, must obey all reasonable directions of the partnership, must refrain from acting outside the scope of the partner's actual authority. And 4th, duty to provide complete and accurate information, must provide complete and accurate information concerning the partnership. Part 4, liabilities owed to third parties, agency theories, imputing knowledge to the partnership, civil liabilities, and criminal liabilities. I probably would not actually discuss any of those in an essay. Those are liabilities owed to third parties. Under an agency theory, yeah, we discussed that. Imputing knowledge to the partnerships, okay. Civil liabilities, maybe they're referring to torts. And criminal liabilities, I guess I can see how partnerships can be engaged in criminal activities, but I'm not sure what liabilities will be incurred. I guess I am RICO. Disassociation and dissolution. So RICO calls for treble damages for like racketing, which could probably include a lot of different things. Disassociation and dissolution, part 5. Methods is A. B, terminating apparent authority. C, continued authority to wind up. And D, distributing assets. Subpart 6, limited partnership. Subpart 7, limited liability partnership. Subpart 8, limited liability, limited partnership. There's nothing in that section. So let's begin with limited partnership. There's 3 sections in it. formation. Liability limited to capital contribution will be the second part, but there's nothing within that liability limited to capital contribution section. And liability and rights of limited and general partners and dissolution and distribution of assets, there's nothing within that section, probably because it's not much different than what we just discussed in partnership, which was methods terminating apparent authority, continued authority to wind up, and distributing assets, which is not really enough detail, but that would be the order in which you set forth your essay that would happen to be on that issue. Limited partnership formation. Need one or more general partners plus at least one limited partner and a certificate of limited partnership filed with the Secretary of State, Records Office, and agent for service of process. So that's what's needed for formation, and actually some variant of it makes up the definition of limited partnership. The definition of partnership is two or more carry on a business for profit. Limited liability to capital contributions, limited, so Part C, liability and rights of limited and general partners, 1 and 2. 1, limited partner, just listing that there's no personal liability, no duties owed except as specified otherwise in the partnership agreement. And second, general partner, listing that they're jointly and severally liable for all partnership obligations. They can have rights of a limited partner but cannot forego duties of a general partner. Limited fiduciary duties of care and loyalty apply, but a partner does not automatically violate duty of loyalty merely because the general partner's conduct furthers his own interest. Dissolution and distribution of assets. So the last, second to last part, the penultimate part, is the limited liability partnership formation, statement of qualification, registration filed with the Secretary of State, and B, liability of partners. No personal liability except that a partner remains personally liable for her own wrongful acts. So we've finished covering the essay writing outline for agency and partnerships. I'm passing through civil procedure because that's actually in my civil procedure playlist. I'm going to pause on community property, and I'm going to do that because it'd be ideal to read this over. This is an area of law that's only tested on essays. So for part 1, preliminary considerations and issues, and California. A, B, and C for the preliminary considerations and issues is the organization of the answer provided by the assets and or the liabilities of the parties. B, be sure to demonstrate your knowledge and understanding of basic presumptions of community property and specific rules applied to particular assets. And C, follow the basic steps of the analysis approach below. The approach is 5 steps. In step 1, state basic presumptions of California community property law and, if applicable, quasi-community property. Step 2, are there any issues that affect all or most of items of property, for example, transmutation, and what give rise to this litigation? Step 3, organize your answer by item of property. Step 4, analyze the character of each item of property, starting with the source, general presumptions. When was the asset acquired? What was the source of funds used to acquire the asset? Where was the assets acquired? And B, actions the parties which may have changed the circumstances of the asset. C, are there special rules, cases, or presumptions that apply? And D, how should the property be distributed? Step 5, discuss preemption issues, if any. Which is really only going to come up with like quad pros, savings bonds. Yeah, just like retirement vehicles and savings bonds. Writing an essay. Start by explaining basic presumptions governing community property. California is a okay, so this is your example. Follow the sample. California is a community property state. All property acquired during the course of a marriage is presumed to be community property. All property acquired before marriage or after separation is presumed to be separate property. In addition, any property acquired by gift, devise, or bequest is presumed to be separate property. With these basic principles in mind, each of the items of property will be examined. Note: if quasi-community property is implicated by the facts, add quasi-community property is property acquired by either spouse that would have been community property had the spouse been domiciled in California at the time of the acquisition. So I read that fast because it's like that's all we keep doing is writing that at the beginning of every essay. It gets kind of old. Part B, analyze issues affecting all or most of the assets. For example, in some questions, there is a transmutation that affects all of the assets. I want to discuss the issue like this at the outset. Likewise, you might want to discuss the basic rules regarding what happens to property at divorce or death, depending on what type of question. So at divorce, the community, this is a sample language for you. At divorce, the community assets will be equally divided in kind unless some special rule requires deviation from the equal division requirement. Or, quote, at death, the decedent can devise all of his separate property in half of the community property. If the decedent dies intestate, the surviving spouse is automatically entitled to the decedent's share of the community property and to 1/3 of all of the decedent's separate property, depending on whether the decedent left issue or parent surviving. Part C, separate each item of property. 1, isolate your asset acquired by the spouses and use the heading to break up the discussion by asset. 2, isolate any liabilities incurred by the spouses and use the heading to break up your discussion by liability. Discussions and basic presumptions that govern each asset or liability. 1, to determine the character of any asset, courts will trace back the source of funds used to acquire the asset. A mere change in form of an asset does not change its characterization. For each asset or liability, determine whether any special classification exists and set forth the classification's rule. Personal injury awards. 1, 2, 3, and 4. 1, community property is the cause of action arose during marriage. Right. So we're talking about personal injury awards. They are community property if the cause of action arose during the marriage. And second, if the cause of action arose before marriage or after separation, the award is separate property. At divorce, community property personal injury awards will be awarded entirely to the injured spouse unless the interests of justice require otherwise. Personal injury awards against the other spouse are always a separate property of the injured spouse. Retirement benefits. Community property if earned during the course of marriage, and secondarily for retirement pensions and other retirement benefits earned before and during marriage. Courts use the time rule to determine how much of the pension is attributable to community property labor and how much is attributable to separate property labor. Part C, disability pay and workers' compensation benefits. Either community property or separate property, depending on the wages they were designed to replace, is how you'll determine if between community property or separate property. To the extent disability benefits are taken in lieu of retirement benefits, disability benefits will be treated as retirement benefits. So that would be disability. How you classify disability pay is what they're designed to replace. To the extent disability benefits are taken in lieu of retirement, then they will be treated as retirement benefits. And we know from above that retirement benefits are community property if they're owned during the marriage, or if they're earned both during and before the marriage. The courts are going to use one of the two rules. to determine what character they are. And I don't have the name of those rules right now. He's dead on camera? It's your turn to read. No? I'm gonna read now. Let me do other stuff. So, we're now going to go on to severance pay. It's about the same analysis. Courts are split. If you're going to raise both sides' arguments. So courts that treat severance as separate property do so because they believe the severance pay replaces future wages that would have been received. For stock options, moving right into stock options, is a form of employee compensation. It's treated as community property or separate property depending on when and why they were earned. Courts will prorate the options to determine the respective community property and separate property shares. Business and professional goodwill will be community property if it was earned during the marriage. Education and training is not community property. The community will be entitled to reimbursement if community property funds were used to pay for education or training, and the education enhanced the earning capacity of the spouse. The community is not entitled to reimbursement if A, B, or C. A, the community has already benefited from the education or training. B, the other spouse has also received community funded education, or the need for spousal support is reduced by the education or training. So by already benefited from the education or training, there's a 10-year assumption or presumption if the education and training benefited the community for 10 years, then there's no need to reimburse the community because the earnings capacity enriched the community already. Property acquired with community and separate property. When property is acquired with community property and separate property funds and no title presumption applies, the community and separate property interests are determined by apportioning their respective contributions. This comes from the marriage of Moore. Finally, somebody's going to say it. The most common situation is when a spouse acquires property prior to marriage but uses community property funds to pay off the mortgage. Here's an example. And listen carefully because none of the other BARBRI materials actually talk about this case and actually provide the calculation. So, Hal acquires a home for $100,000, paying $20,000 down and obtaining a mortgage for $80,000. 1 month later, he marries Wanda. During the marriage, community funds are used to pay off $30,000 on the mortgage. Hal and Wanda are now getting divorced. How should the property be divided? When community and separate funds are used to purchase an asset, the community and separate property acquire a pro rata ownership interest in the asset. To determine the respective shares of ownership, you start by figuring out the percentage that each contributed to the purchase price. The separate property initially contributed $20,000 plus a mortgage of $80,000. So the mortgage is separate property because it was acquired prior to marriage, and the intent of the lender must have been to rely on each as separate property. From this amount, we must subtract the amount the community property contributed to pay off the mortgage, which was $30,000. Thus, the separate property contributed 20 plus 80 minus 30, which is 70. The community contributed $30,000 of the initial purchase price. Thus, to determine the separate property share is 70,000 over 100,000, or 7/10, and the opposite, 3/10, is the community property share, which is 30,000 over 100,000. At divorce, the separate property is entitled to its actual contribution of the purchase price, 20,000, plus 7/10 of the appreciation, and the community property is entitled to 30,000 plus 7/10 of the appreciation. So I can explain this in a calculation format. So the acquisition price is $100,000. We're going to assume no appreciation in this example. Or we're just going to use the purchase price as the denominator. So separate property equals, the separate property share equals the down payment plus the mortgage minus what the community paid over the purchase price. Whereas, literally nothing to write on. The community property share is what the community property paid over the purchase price. So I'll write community property pay down over the purchase price. This is the factor where you got 3/10 from. The separate property factor was, again, over the purchase price, but the hard part was the down payment plus the mortgage minus the community property pay down. Now, this factor gets multiplied against the appreciation to show you how much goes to the community. Basically, or what the community interest is, which then gets divided in half because one of the divorcing spouses is the one who brought this asset to the community, so they're going to actually get half of it. So I'm just going to say divided by 2. That's actually what the is going to go to one of the spouses. So the spouse that brought the asset is going to receive so this factor times the appreciation plus their down payment comes back to them plus half of community property share. Right? So that's your Moore formula. There's 2 ways to do it, which is why we're getting stuck on the factor alternative. So we can move on. By contrast, when community property is used to improve the separate property of a spouse, the community does not obtain a pro rata ownership interest in the asset, but may be entitled to reimbursement. When a spouse uses community property to benefit the separate property of the other spouse, a gift is presumed. When a spouse uses community property to benefit the spouse's own separate property, the community property is entitled to a reimbursement. Community property is entitled to the cost of the improvement or the increase in value of the separate property, whichever is greater. Actions by the spouse is altering the character of property. So this is going to be your transmutation section. It is very long. Kind got like 4 more pages of community property. So this is like an entire outline. Actions by the spouses altering the character of property. Nuptial agreements before marriage, are enforceable but must be in writing to satisfy the statute of frauds. Transmutations. Do they mean to say before, during? Transmutations, agreements during marriage. Defined, a transmutation is an agreement between spouses to change the character of an asset or series of assets. 2. Explain the requirements. A transmutation must be made in a written express declaration that is consented to or accepted by the spouse whose interest is adversely affected. The writing must expressly declare that a change in the ownership property is being made. 3rd, apply to the facts. Here, there was or was not a valid transmutation because ... Taking assets in joint title. This is the 3rd scenario. What happens to jointly titled property differs depending on whether the property is being divided at divorce or at death. First, identify whether the characterization is taking place at divorce or at death. Set forth the applicable rule completely. At death, Lucas applies. Under Lucas, when a married couple takes title in joint and equal form, it is inconsistent with the preservation of separate property interest in the asset. Any separate property used to acquire the asset is presumed to be a gift of the separate property unless there is an oral or written agreement to the contrary. Or, alternatively, at divorce, all property taken by a married couple in any joint form is presumed to be community property. Any separate property used to acquire the jointly titled asset does not give the separate property a pro rata ownership interest in the asset, but the spouse who contributed the separate property is entitled to reimbursement without interest or appreciation. So separate property used to acquire a jointly titled asset does not give the separate property a pro rata interest in the asset, but the spouse who contributed the separate property is entitled to reimbursement. And 3rd, apply the applicable rule to the facts of the case and state your conclusion. D, community labor enhancing the value of separate property. When community labor is used to enhance the value of a separate property business, the community is entitled to share in an increased value of this separate property. Explain why the community has any interest. Here, although H's business is separate property, the community is entitled to a share of appreciation of that business because H's labor during the course of the marriage was used to increase the value of the business. Explain the different formulas for calculating the community interest and explain how they apply to the facts. Pro rata accounting is used when the increase in value of a separate property business is primarily the result of community labor. Using pro rata to determine the value of a separate property at the beginning of the business and give it a fair rate of return over the course of the marriage. Normally, this is the legal interest rate, 10% simple interest, calculated. Oh my God, I can't see. Save my life. Calculated 10% simple interest calculated annually. The separate property is given the initial value plus the fair rate of return. The remainder is community property. Here, if pro rata accounting were used, apply to facts. Van Camp, accounting is used when the increase in value of a business is primarily the result of the unique nature of the separate property asset. Using Van Camp, determine a fair salary for the community labor. Multiply that by the years of the marriage. Subtract any salary already received and the amounts paid for community expenses. The result is the community property share. The rest is separate property. Here, if Van Camp accounting were used, apply to the facts. Explain which method should be used. Here, Van Camp accounting should be used. The principal reason for the increase in value of the business was not H's labor, but rather the increase in the value of the product sold by the business due to wartime rationing by the government. That's an example, but like they don't realize that by using an example that they're not actually stating a general rule that we can use for every other fact set. So what I've been known to say is rather, the increase in value of the business was not H's labor, but rather the increase in the value of like the assets owned by the business. I guess here you could also say the product sold or the community interest in the product. I've been known to say like a good market. So, it's kind of hard putting that into words. Part E, after characterizing, explain what happens to property for purposes of question. Distribution at divorce. State the basic rule. The basic rule of divorce is to divide each community property asset equally in kind. Thus, each spouse is given half of each community asset. Explain whether there are any reasons to deviate from the equal division rule. Misappropriation by one spouse. Liabilities exceed assets. Educational debts are assigned to the spouse who received the education. Tort liabilities are assigned to the tortfeasor spouse if the liability was not for the benefit of the community. And family home may be awarded to the person who is given custody of the minor children. Distribution at death. If the spouse dies with a will, the spouse is entitled to dispose of all of his or her separate property and half of the community property. If the spouse dies without a will, the community property is awarded entirely to a surviving spouse. Between 1/3 and all of the decedent's separate property will be awarded to the surviving spouse depending whether there is issue or parent surviving. Quasi-community property. Explain what it is. Quasi-community property is property acquired by the couple while living in another jurisdiction that would be classified as community property had the properties been domiciled in California. Explain what happens at divorce. At divorce, quasi-community property is treated exactly like community property. Explain what happens at death. At death, the surviving spouse has a 1/2 interest in the quasi-community property title in the decedent's name. The decedent does not have an interest in the quasi-community property title in the survivor's name. Non-marital relationships. I was just wondering if we were going to skip this. Lawful marriage requires both legal capacity and the performance of legal procedures. A putative spouse is not lawfully married but has a good faith belief that he or she is legally married. Quasi-marital property. Unmarried cohabitants are persons who reside together but who are neither lawful spouses nor putative spouses. 1, contract principles apply between cohabitants, and 2, contracts upheld so long as consideration does not violate public policy. I'm not going to give the example there. Management and control during marriage. Explain the basic rule. The general rule is that during marriage, the spouses have equal management and control of all community assets. Explain whether there is an applicable exception to the equal management rule. 1, 2, 3, and 4. Real property transfers. Both spouses must join in a transfer of real property or a conveyance. Can't be done with just the signature of one spouse. I mean, I wonder if it's not titled as tenants by the entirety. I don't want to get too complicated. 2, personal belongings, including clothing and furniture. 3rd, spouse managing a business is given primary management and control. And 4th, bank accounts in the name of one spouse alone. F, in the last section, is discuss any preemption issues if they exist. Explain the basic concept. Under the Supremacy Clause, federal law preempts inconsistent state laws. In some instances, federal law preempts California from applying community property concepts to certain assets. Explain whether preemption applies or not. What's preempted? Federal homestead claims, military life insurance benefits, U.S. savings bonds, and Social Security benefits. What's not preempted is railroad retirement benefits, military retirement benefits, and copyrights. So, what's the next topic that we're going to discuss? Constitutional law. I'm not reading that right now. Contracts and sales, not reading that right now. Corporations is one that I did intend to read. With any luck, we'll get through it. Preliminary consideration issues. Traditionally, corporations, and this again is the essay writing approach to corporations questions. So initially consider that corporations were tested on its own, but now can be joined with partnership and or agency. Statutory law, fiduciary duties. I guess this is the order of your essay would begin with statutory law, fiduciary duties, federal securities law, and your issues checklist is that you should remember to determine if your essay includes all of the relevant elements. Those include 1 through 7, organization and formation of the corporation, 2, shareholders, 3, directors, 4, officers, 5, fundamental corporate changes, 6, dissolution and liquidation, and 7, federal securities laws. So probably in that order is going to be this kind of more detailed description of what's in each of those 7 elements. So beginning with organization and formation of corporation, we have 5 parts. A, have articles of incorporation been filed? 1, 2, 3, and 4. Name of corporation must be included. Cannot be similar to existing names. Expand this. Number of authorized shares must be included. Also must include the name and address of incorporators and of registered agent. Watch for clause limiting corporation's purpose. Activities beyond scope of purpose are ultra vires and may be enjoined or directors held liable for authorizing such acts. B, when does corporate existence begin? When articles filed by the state. Promoters are generally liable for pre-incorporation contracts. Liability continues even after corporation formed, absent innovation, and corporation does not become liable unless it adopts the pre-incorporation contract. That is, So part C. What if there are defects in formation? There's 5 numbers under this part. 1, a person who purports to act on behalf of a corporation knowing there was no valid incorporation is personally liable. 2, no liability if a de facto corporation. If the defective formation amounts to a de facto corporation, and that would involve A and B, colorable compliance with the incorporation statute, and B, exercise of corporate privileges. 3rd, no liability of corporation by estoppel. People treating business as valid corporation are estopped from denying corporation's existence. 4th, some states do not recognize de facto and estoppel doctrines. And 5th, no corporation recognized. Only those who acted on behalf of the business will be held liable. Passive investors are not liable. So, again, it fails to say that a correctly formed corporation is termed de jure. Moving on to part D, will court disregard corporate entity and pierce the corporate veil? One thing I found is that this is not broadly applied to partnerships, but it applies to corporations and I think the limited liability company, LLC. So The first part of the section is alter ego doctrine, and the grounds is harm caused to third parties because 1, 2, 3, and 4. 1, owners do not treat the corporation as a separate entity. They commingle personal and community property funds. Third, they use corporate assets for personal purposes. And fourth, owners do not hold meetings. And B, parent subsidiary corporations or affiliated corporations can be held liable for this. 2, inadequate capitalization at inception. Must start corporation with sufficient unencumbered capital to meet its prospective liabilities. Perpetrating a fraud cannot be formed to avoid existing liabilities, can be formed to limit future liabilities. And fourth, if the court pierces, generally only active shareholders are liable, and they're generally liable only for tort obligations. So we're going to talk about the capital structure of the organization, but I don't really know why. Well, okay, equity securities, there's a lot of information here. Debt securities and bonds create debtor-creditor relationship, and that's all that's said, thankfully. It's fine to expand on equity securities, i.e. stocks, create ownership interest. The terminology includes 1, 2, and 3, authorized but unissued shares, shares described in the articles but not currently issued. 2, issued and outstanding, shares sold to investors. And 3rd, treasury shares, formerly named for shares repurchased by the corporation, now called authorized but unissued shares, because people are lazy. And they actually are called treasury shares. So maybe not among lawyers, but among accountants, they are still called treasury stock. Subscription agreements to purchase shares from a corporation. Pre-incorporation subscription agreements are irrevocable for 6 months. Got excited. Consideration for shares, acceptable form and amount. What's an acceptable form for consideration for shares under the Revised Model Business Corporations Act, MBCA? Any benefit to the corporation traditionally were only cash, property, or services already performed. Amount for consideration of shares is under NBCA. Amount set by directors and their good faith valuation of the consideration received is conclusive. Traditionally, shares often had a par value minimum consideration and could not be sold for less. I don't know why they think that doesn't exist anymore. Either I'm really old or accounting has greatly changed. Well, maybe. Shareholders voting 1, 2, 3, and 4 on this page, probably more on page 4. Generally, shareholders do not run corporation on the day-to-day basis, with the exception of closely held corporations, which may dispense with the board by shareholders' agreement and run corporation through a different scheme. Shareholders indirectly control corporation by electing officers, amending bylaws, and improving fundamental changes. So those are all the things that the shareholders get to vote for. I mean, not all, but the biggies. And the notice of the special shareholder meeting is been really emphasized, at least in the text and my outline and in BARBRI's materials and lectures. Record shareholders. Shareholders of record on the record date have a right to vote at the annual meeting to elect directors and regarding fundamental corporate changes. 3rd, notice of meetings must be given to shareholders. Annual meeting, date, time, location, special meeting, date, time, location, and purpose, and proper notice. Action taken at the meeting can be nullified and can be waived by attending without complaints, which means ratification. Proxies. Written proxies are valid for 11 months. I think a no action letter is what so I think the shareholder has to abstain from voting or not vote for. I guess they just abstain from voting, and then they bring it up within a certain time. And they can ask for a no action letter from, like, I guess the state body of law or the MBCA. I'm not entirely sure. If it's actionable before suing the corporation. So those are some preliminary actions that have to be taken on an improper notice. So proxies, written proxies are valid for 11 months. There was literally actually a question on the exam on corporations last time. I probably will not get to opening this, but the sample answer's in here. Wherein it probably would be nice to know that written proxies are valid for 11 months. Generally, these are revocable unless they specifically provide otherwise and are coupled with an interest, may be revoked by attendance or later appointment. These are your selected answers. Pretty long. Federal law proxy. Solicitations must fully and fairly disclose all material facts. Prohibits material misstatements and fraud in connection with any proxy solicitation. Materiality. A reasonable shareholder would consider it important in deciding how to vote. So federal law. Oh. Regarding proxy solicitations are that they must fully and fairly disclose all material facts, prohibit material misstatements and fraud in connection with the proxy solicitation, and materiality. A reasonable shareholder would consider it important in deciding how to vote. Quorum. I'm not reading this question from the July bar, because the question itself is over a page long. And I think that the answer is like 11 or 12 pages. Quorum. Generally, a majority of the outstanding voting shares must be present for valid vote. Once the quorum is reached, shareholder leaving does not invalidate voting. Approval. NBCA, if quorum present, action approved if votes cast in favor exceed votes cast against. Some states require a vote for fundamental corporate change. Cumulative voting for directors. NBCA allows articles to provide for cumulative voting. Cumulative voting is automatic in some states. Mechanics. Shareholder can vote shares owned X number of directors being elected, can cast all votes for one candidate or split. Cumulative voting for directors. I do not understand that. I wonder. I don't think they got to it in the bar. Shareholder agreements, that does seem to be discussed in this last bar. Voting trust. Shareholders transfer share ownership to a trustee who votes shares as agreed. Valid in most states for up to 10 years, but renewable. Shareholder management agreements. Used in small corporations. Shareholders may agree to run the corporation any way. Can even dispense with the board. And share transfer restrictions. Ownership interest shares generally are freely transferable. Shares may conspicuously provide for restriction, and restraints must be reasonable. So this was actually tested. That was what really, really, really surprised me. I really do not think this answer probably got there. I think I got there, but I didn't actually know. So I might have actually addressed the issue, but I didn't actually know the law so well. Not only does this person know the law, they know how to apply it, which makes them pretty genius. Because They're like trying to enjoin a corporation from manufacturing bicycles. And talked about ultra vires. I did too. Direct action, right to an injunction. So they did break that. How to bring this action. Validity of agreement to vote together as shareholders. The issue is whether A and B's agreement is valid. The agreement contains two key provisions. A and B agreed to elect themselves to the board and to agree on the election of successor board members, and if they could not agree, they would abstain from voting. And two, A and B agreed that once they became directors, they would select P as new president of Corp. Moreover, the agreement indicated that it would be binding on subsequent owners of their shares, and they indicated as such on the actual share certificates. Here, each of the two provisions will be addressed separately. First provision provides for how A and B will vote as shareholders. The shareholder voting agreement, known as a voting pool, is permissible as long as a signed written agreement clearly setting forth the terms. Here, A and B will argue that they entered into a valid shareholder agreement when they agreed to elect themselves to the board of directors. Shareholders are permitted to enter into contracts agreeing on how to vote at director elections, and here, A and B entered into a signed written agreement doing just that. Thus, the provision of the shareholder agreement, which provides that A and B will vote to elect themselves to the board of directors, will likely be upheld as valid. However, it is less clear whether the voting agreement will be binding on successor shareholders. This is discussed further below. So that is literally what some other student wrote in response to this question. So some of the students that don't have jobs can memorize every single nook and cranny of all of the law that has to be memorized to take the exam, including corporations, which are finding to be very impressive. Because I think I barely got to it, but again, looking at shareholder agreements according to BARBRI, voting trusts, shareholder transfer share ownership to a trustee who votes shares as agreed, valid in most states for up to 10 years, but renewable. Shareholder management agreements used in small corporations. This is what was just discussed. Shareholders may agree to run the corporation anyway and can even dispense with the board. And share transfer restrictions, ownership interest shares generally are freely transferable. Shares may conspicuously provide for restriction, and restrictions must be reasonable. So inspection rights are limited to books, papers, accounting records, etc. within 5 days written notice, and proper purpose is required. This is a purpose related to the shareholders' rights. An unqualified right, regardless of purpose, to inspect articles, bylaws, minutes of shareholder meetings, names and addresses of current directors, and recent annual reports. Preemptive right. There's a right to purchase shares to maintain proportionate ownership interests. Under MBCA, exists only if provided for, and where provided for does not apply to shares issued as compensation. A. B. Shares issued within 6 months of incorporation. C. Shares issued for consideration other than money. And D. Non-voting shares with a distribution preference. Shareholder suits direct versus derivative, which was something that this answer got to. How do they say it? Derivative shareholders lawsuit. A shareholder of a corporation may bring a derivative lawsuit on behalf of the corporation against its own directors and officers, where the shareholder believes those directors and officers are not protecting the rights and interests of the corporation. In order to do so, the shareholder must have been a shareholder at the time of the wrong and continue as a shareholder throughout the time of the suit, adequately represent the interests of the shareholders, and make a demand on the board unless demand would be futile. And I'm not going to read the facts. Then they talk about ultra vires. And then direct action. E can also potentially bring a direct action on the grounds that his shareholder rights were violated because he was not permitted to vote on a fundamental corporate change, the amendment of the Articles of Incorporation. You will argue that P's actions were an attempt to unilaterally amend the Articles of Incorporation without calling a special shareholder meeting, voting meeting, and as such, E's rights as a shareholder were violated by a corporation, and E may be permitted to sue directly on these grounds. And then there's a right to an injunction. In order to obtain a permanent injunction, the moving party must show success on the merits, inadequate remedy at law, irreparable harm, and balance of hardships and equities tips in their favor. The public interest does not disfavor injunction. E can likely establish these elements given the corporation engaged in a wrongful ultra vires action that will likely cause eminent harm to the shareholders' interests in the form of lost profits. Business judgment rules discussed. I wonder if BARBRI's got it in here. Let's go to distribution. No, let's read shareholder suits according to BARBRI. Direct versus derivative. A direct suit is to enforce the right of a shareholder. Derivative suit is to enforce the right belonging to the corporation. 1, 2, and 3. 1 must have owned shares at the time of the wrong. Must maintain ownership throughout the suit and demand board to bring a suit unless futile in some states. Dismissal. If a majority of directors with no personal interest determines in good faith that suit is not in best interest of the corporation. And recovery. Direct suit goes to the shareholder and derivative suit goes to the corporation usually. Distributions. Generally in the form of dividends or of assets after dissolution. There's no right to receive unless or until declared by a board. A, B, and C. A, insolvency limitations. There's no distribution of dividends if corporation is unable to pay its debts as they become due or the total assets are less than the total liabilities. Preferences. Shares may have a preference to distributions. There's 1, 2, and 3. Cumulative is 1. Cumulative if earned and participating. Under cumulative, if distribution not declared or paid in a certain year, it accumulates until paid. Cumulative if earned, preference accumulates only if profits for a year were sufficient to pay preference. And participating, receive stated preferences and a share of the distribution made to common shareholders. Director liability, 1, 2, 3, and 4. Director votes for an unlawful distribution is personally liable for the excess. Director may seek contribution from other directors who voted for distribution. Third, directors may recover from a shareholder who received a distribution knowing it was unlawful. And fourth, good faith defense may rely on accounts or reliable officers and employees who indicate distribution is lawful. I just realized that more likely than not, this essay is probably written by like a BARBRI professor because they have to sit for these exams so that they can prepare these materials. Or at least that's my assumption. So I don't really think this is too necessary. I can't wait to see if they use one of my answers. But they probably didn't because I didn't underline anything. And all of these headings are underlined. So when you're using headings, only this one has bold and not underline headings. But I can tell it's not mine. All of the rest of the answers have underlined their headings. So that's how you're going to do it. All right. Shareholder liabilities. Shareholders are not fiduciaries. May act in self-interest. Exception, controlling shareholder cannot use control to obtain a special advantage at the expense of the minority shareholders. What did I just read about director liability? If they vote for unlawful distribution, they're personally liable. And they can seek contribution and recover from a shareholder who received a distribution knowing it was unlawful, and they have a good faith defense, may rely on accountants or reliable officers or employees to indicate the distribution was lawful. This is going to be a while because I have part 3, directors, part 4, officers, part 5, fundamental corporate changes, 6, dissolution and liquidation, and 7 is your SEC rules. So like 6 more pages to read, and they're really wordy. And by 6, I think it means 6. So A, voting. Meetings of directors must attend in person, no proxies or through telecommunication equipment if all Participating directors can simultaneously hear each other. No particular notice is required for regular meetings. Special meetings typically require 2 days notice of date, time, and place, but not purpose. And quorum of directors must be present if vote is to be taken. And what else is going on? Approval of action requires affirmative vote of a majority of the directors present. 2, delegation to executive committees may exercise authority given to them by the board. A and B, it's composed of 2 or more directors in most states, and the exceptions is that in most states, committees may not declare distributions, fill board vacancies, or amend the bylaws. Liabilities and indemnification of the directors within the directors section, starting with liabilities, is the business judgment rule generally protects directors from personal liability to corporation shareholder. Director must act in good faith with the care that an ordinary prudent person in a like position would exercise, and in a manner reasonably believed to be in the best interest of the corporation. Articles may further limit or eliminate director personal liability to corporation or shareholders, except to the extent the director received improper benefit. 2, for liability for unlawful distributions, or 3, for intentionally inflicted harms or criminal violations of law. C, reasonable reliance defense. 1, director may defend suits with a claim of reasonable reliance on opinions, reports, etc., prepared by experts or reliable employees. Waste. A director has a duty to prevent corporate waste. E, no self-dealing without disclosure and approval. Duty of loyalty. 1, a transaction between a corporation and a director will not be set aside for self-dealing if A, a director disclosed all material facts and transaction was approved by disinterested directors or shareholders, and B, the transaction was fair to the corporation. F, corporate opportunity doctrine. 1, a director may not divert to himself a business opportunity within the corporation's line of business without first giving the corporation an opportunity to act, aka usurpation. Remedy, corporation may recover director's profits or force director to convey the opportunity to the corporation. So that first part is called disgorgement. Indemnification, successful defense. If director is sued as a director and successfully defends, corporation must indemnify for expenses. Unsuccessful. If director is unsuccessful in defending, corporation has discretion to indemnify if the director complied with the business judgment rule standards. 1, exceptions. Director is found liable to the corporation or received an improper benefit. Indemnification. And corporations may purchase liability insurance to cover directors even if they would not be entitled to indemnification under the circumstances. All right, so indemnification under the 2 circumstances of whether the director successfully defends himself or is unsuccessful. If a director is sued as a director and successfully defends, the corporation must indemnify for expenses. If they're not successful, I believe that they may. They have discretion to indemnify the director complied with the business judgment rule standards. The exception is if the director is found liable to the corporation or received an improper benefit. And the other is if they settled. I don't remember if that falls into a successful defense or unsuccessful one. But more likely than not, they're going to settle. So, officers. There's so much of this left. Required officers. NBCA does not require any particular officers, but rather allows corporations to have officers described in bylaws or appointed by directors. Some states require at least 2 officers, a president and a secretary, to certify corporate acts and records. Third, generally a person may hold more than 1 office, but some states prohibit a president and secretary from being the same person. B, appointment and removal. 1, 2, and 3. Officers are appointed by the board of directors, not by shareholders. Officers may be removed by the board of directors. If removal is in breach of contract, officer is entitled to damages. Authority. Officers have the actual authority given by the board, articles, and bylaws. Officers have apparent authority to do whatever someone in their position would normally have authority to do. Liabilities and indemnification, if not otherwise set forth in articles and bylaws and policies and procedures. Okay. So, liabilities and indemnification. Officers owe corporation duties similar to those owed by directors. Officers have right to indemnification similar to directors. Fundamental corporate changes. This is part 5. The types of these include amendments to articles, bylaws, consolidations, share exchanges, disposition of substantially all assets outside of the regular course of business. General procedure, board resolution, notice to shareholders, shareholder approval, and articles of the change filed with the state. Yeah. Merger of corporations generally must be approved by directors and shareholders of both corporations. There's exceptions, for instance, the parent subsidiary merger, or when rights of survivors, shareholders are not significantly affected. Dissenters, appraisal remedy. Shareholders who do not like a fundamental corporate change may force the corporation to purchase their shares at a fair price if they. 1, 2, and 3. This is kind of the same process that I was talking about in the inadequate notice for special meetings for voting on amendments to like bylaws. 1, give corporation notice of intent to demand appraisal rights before the vote is taken. 2, do not vote in favor of the change. And 3, demand payment after the change is approved. E, tender offers. A widespread public offering to purchase a substantial percentage of the target shares. 2, regulation under the Federal Williams Act. If a bidder makes a tender offer and the offer will result in the bidder obtaining more than 5% of a class of securities of the target, the bidder must file a Schedule 14D. What's he doing? He wants to play? You want to play? What do you want to play with me? My slipper. Look at this. All right, so we're talking about tender offers here. We're talking about Twitter. Talking about Twitter now. A widespread public offering to purchase a substantial percentage of the target shares. So that means like you become a majority or you become a substantial shareholder. So you have the right to ask for all of the other shareholders like names and addresses. And then you send them a tender offer. You actually have to file like a 14D. Yep. Oh, it says so right here. And under the Federal Williams Act. And you got to let these people know that you're going to try to buy them all out. And you do it at like 3 times what the stock is worth. You get everybody's shares, you become a majority shareholder, and then there's some limitations to what you can do. Well, I'm just going off. Regulation under the Federal Williams Act. If a bidder makes a tender offer and the offer was sold and the bidder obtaining more than 5% of the class of securities of the target, the bidder must file a Schedule 14D. Schedule 14D contains extensive disclosure regarding the bidder's identity, source of funds, past dealings with the target, and plans concerning the target. An offer must be open for at least 20 days and must be open to all members of the class of securities sought. What else? Shareholders must be permitted to withdraw tendered shares while the offer remains open. If the offer is oversubscribed, the bidder must purchase on a pro rata basis from among the shares deposited during the first 10 days of the offer. If the offer price is increased, the higher price must be paid to all tendering shareholders, and the management of the target must either 1, give its shareholders a recommendation concerning the offer with a statement of reasons, or 2, explain why it cannot make a recommendation. And the Act also prohibits any false or misleading statements or omissions in connection with the offer, which is actually probably... So, like, you can't go out into the newspaper and, like, you can't file a 14D and then go out in the newspaper and say, like, something else. Gaslight. I'm kidding. There's another thing that has to happen. Once a substantial percentage of the target shares have been obtained by the tender offer, aka, oh my god, I think of a hostile takeover, but what is the name of the hostile in the hostile takeover? Acquirer. They can't vote the majority of the shares on, like, the second iteration of the tender offer, because these tend to be done in 2 parts. Something like that. Control share acquisition statute. It says here, this might be it. The state law providing that if a designated stock ownership threshold is crossed, the shares so purchased will not have voting rights unless the holders of the majority of the disinterested shares vote to grant voting rights in the acquired shares. And limitation on the scope must be limited to the corporations or transactions having a significant connection to the regulating state. So that's exactly what I was going to say. I just didn't know it was in section F. So now we're in part 6, dissolution and liquidation. Voluntary dissolution. If shares have not yet been issued or the business not been commenced, a majority of the incorporators or initial directors may dissolve the corporation by delivering articles of dissolution to the state. After shares have been issued, corporation may dissolve by a corporate act approved under the fundamental change procedure. Effective dissolution: 1, corporate existence continues. 2, corporation not allowed to carry on any business except business appropriate to winding up and liquidating its affairs. And 3, a claim can be asserted against a dissolved corporation, even if it does not arise until after dissolution, to the extent of the corporation's undistributed assets. If the assets have been distributed to the shareholders, a claim can be asserted against each shareholder for a pro rata share of the claim to the extent of the assets distributed to the shareholder. Corporation cannot cut short the time for bringing known claims by notifying claimants of a filing deadline. Unknown claims can be limited to 5 years by publishing notice of the dissolution in a newspaper in the county where the corporation's known place of business is located. Administrative dissolution: the state may bring an action to administratively dissolve a corporation for reasons such as the failure to pay fees or penalties, failure to file an annual report, or failure to maintain a registered agent in the state. That's an administrative dissolution. Judicial dissolutions are when the Attorney General seeks judicial dissolution on the ground that their corporation fraudulently obtained its articles of incorporation, or that the corporation is exceeding or abusing its authority. Shareholders may also seek this on any of the following grounds: A, B, C, or D. The directors are deadlocked in the management of corporate affairs. The shareholders are unable to break the deadlock, and irreparable injury to the corporation is threatened, or corporate affairs cannot be conducted to the advantage of the shareholders because of the deadlock. The directors have acted or will act in a manner that is illegal, oppressive, or fraudulent. C, the shareholders are deadlocked in voting power and have failed to elect one or more directors for a period that includes at least 2 consecutive annual meeting dates. Or D, corporate assets are being wasted, misapplied, or diverted for non-corporate purposes. And third, creditors may seek judicial dissolution if the corporation has admitted in writing that the creditor's claim is due and owing, and the corporation is insolvent, and the creditor's claim has been reduced to judgment. Execution of the judgment has been returned unsatisfied, and the corporation is insolvent. So we're going to move to the next page. And that's page 10. Rule 10B5, Section 16B and Sarbanes-Oxley Act. Rule 10b-5 makes it illegal for any person to use any means of or instrumentality of interstate commerce in connection with the purchase or sale of any security to employ any scheme to defraud, make an untrue statement of material fact, or omit a material fact, or engage in any practice that operates as a fraud. All of these elements are further defined as by or following. Materiality is a substantial likelihood that a reasonable investor would consider it important in making an investment decision. Intent, the conduct must have been undertaken with an intent to deceive, manipulate, or defraud, for example, scienter. Recklessness as to the truth also appears to be sufficient culpability to meet the intent threshold. The defendant need not have purchased or sold any securities. For example, non-trading defendant can be held liable to a person who purchased or sold securities on the market on the basis of a misleading press release. D. A private plaintiff must prove reliance on defendant's fraudulent statement or conduct. In cases of omission, reliance generally will be presumed. E. A private plaintiff must show the defendant's fraud caused plaintiff damages. Damages are limited to the difference between the price paid or received and the average share price in the 90-day period after corrective information is disseminated. Rule 10b-5 also prohibits most instances of trading securities on the basis of inside information not disclosed to the public and that an investor would think is important when deciding whether or not to invest in a security. 1, 2, 3, and 4. A person violates Rule 10b-5 if by trading he breaches a duty of trust and confidence owed to 1. The issuer, 2. Shareholders of the issuer, or 3. In the case of misappropriation, another person who is the source of material non-public information. 2. Anyone who breaches a duty not to use inside information for personal benefit can be held liable under Rule 10b-5. 3. Where an insider gives a tip of inside information to a friend or relative who trades on the basis of the information. The tipper can be held liable under Rule 10b-5 by making a gift of confidential information to a trading friend or relative. The benefit to the tipper is inferred by the relationship. The tipper need not receive any pecuniary interest or something of value in exchange. A tippee acquires a tipper's duty of trust and confidence, which the tippee breaches if he trades on information with knowledge that it was improperly disclosed. That's everything involved in Rule 10b-5. Rule 16b, I think this is a short swing. Yeah. Requires surrender to the corporation of any profit realized by any director, officer, or shareholder owning more than 10% of a class of a corporation stock from the purchase and sale or sale and purchase of any equity security within the 6-month period. Sale or purchase test. Type of sale in which abuse of inside information is likely to occur. That's the sale or purchase test. Is it the type of sale in which abuse of inside information is likely to occur? Transactions occurring before one becomes an officer or director are excluded, but transactions occurring within 6 months after ceasing to be an officer or director can be covered. This section applies to publicly held corporations. Profit is determined by matching the highest sales price against the lowest purchase price for any 6-month period, may be either a gain or an avoided loss. Your short swing, and that's not really a very good definition of the short swing. So maybe define it as a shareholder owning more than 10% of a class of a corporate stock from the purchase and sale or sale and purchase of an equity security within a 6-month period. I still don't like that definition. So I think it's like 10% interest is sold or purchased during a 6-month period. I think those are the 3 criteria. And the idea is that it was either for a gain or to avoid a loss. And it was kind of based on, well, it might not have needed to be based on an abuse of inside information if, say, for instance, the party's an officer or director. Or no, actually, officer or director is the fourth element, or is an element. So yeah, so both of those things seem to need to occur. It applies to publicly held corporations. Your profit is surrendered. Sarbanes-Oxley, this talks about corporate governance requirements. Applies to publicly held companies, requires covered companies to establish an audit committee of the board members, which oversees work performed by a registered public accounting firm, establishes internal procedures for receiving and handling complaints about the company's accounting, internal accounting controls, and auditing procedures. That's a whistleblower hotline. The CEO, CFO, or similar persons of covered companies must certify in each report, among other things, that the officers review the report based on the officer's knowledge the report is true and does not contain any material omissions, and the signing officer is responsible for establishing internal controls, has designed such controls and ensure the material information is made known to the officer, and has evaluated the controls within 90 days prior to the report. If the company is required to restate its financial reports because of misconduct with respect to the reports, the company's CEO and CFO must reimburse the company for any bonus or other incentive-based compensation received by them during the 12-month period after the inaccurate reports were filed with the SEC or made public. And SOX generally prohibits covered companies from making any personal loans to directors or executive officers, and SOX provides that the statute of limitations for private cases of securities fraud in the later 2 years after discovery of the facts giving rise to the cause of action or 5 years after the action accrued. So that's going to be corporations' essay writing outline. I'm actually not going to quit. I'm skipping through criminal evidence to get to professional responsibilities. I just want to lay out the outline because so the broad issue checklist includes 1, the attorney's duty to the client, the attorney's duty to third parties is 2, third, the attorney's duties to the court, and 4th, the attorney's duties to the public and the profession. It can't be just those 4. In summary, wow, this is actually really nice. The attorney's duty to the client includes the duty of loyalty, silence, competence, financial integrity, and other duties to the client. So what she says is to Professor Heisch says, you will write in your essay, the lawyer has a duty of, fill in the duty, to, fill in the person or thing, and then if it is those to the client, which we said was loyalty, silence, competence, financial integrity, those will be written. She adds confidentiality here is confidentiality, loyalty, financial responsibilities, and competence. When you order it that way, it's CLFC is the mnemonic, but I forget what that means. It's so funny. She gave the mnemonic, but she didn't. Okay, here it is. Clients love fierce counsel. Courts feel differently. Okay, so the duties to the entities other than your clients, which is the court, your adversary, third parties, the public, is candor, truthfulness, fairness, dignity, and decorum. So clients love fierce counsel and courts feel differently. Clients, confidentiality, love, loyalty, fierce, financial responsibilities, counsel, competence, and courts, candor, truthfulness, feel fairness differently, dignity, decorum. And let's read it out in summary form here. The attorney's due to the client is, I'm going to start with confidentiality and then go to loyalty, financial responsibilities, competence, and diligence. and the attorney's duty to third parties, the duty to opposing parties in litigation, duty to accept representation, and the special duty of prosecutors. God, I feel like this is not very complete. So, like, you can't discriminate, and your honesty requirement can be somewhat lowered if you're in like good faith negotiations. And what did I feel was most missing from these third parties? Something about marketing isn't in here, like making statements about your client's case. Oh yeah, speaking to an unrepresented client. That's what I thought was missing. So anyway, let's just move on to the attorney's duty to the court, candor, honesty, witnesses, and jurors. So there's saying that out, reading that out is the duty of candor, the duty of honesty, and duty to witnesses and jurors. And lastly, the attorney's duty to the public and profession, the duty to avoid unauthorized practice of law, the duty to avoid false or misleading advertisements, and the duty to not improperly solicit clients or act as though you can like buy the court's partiality. Oh, there's a breakdown. There's a further breakdown of all of this and compared to California. So I would love to keep going. It looks like I need to plug my computer in. I'd love to keep going, but it's also going to be an awful long video. So we're shutting this down. We'll do it again. And when we do it again, we'll cover professional responsibility, will, and trust. Because we covered here agency, partnership, corporations, and community property. These are all